The Massachusetts General Court is the state legislature of the Commonwealth of Massachusetts. The name, General Court, is a holdover from the earliest days of the Massachusetts Bay Colony, when the colonial assembly, in addition to making laws, sat as a judicial court of appeals. Before the adoption of the state constitution in 1780, it was called the Great and General Court, but the official title was shortened by John Adams, author of the state constitution. It is a bicameral body. The upper house is the Massachusetts Senate, which is composed of 40 members. The lower body, the Massachusetts House of Representatives, has 160 members. It meets in the Massachusetts State House on Beacon Hill in Boston. The current president of the Senate is Stan Rosenberg, and the Speaker of the House is Robert DeLeo. Democrats hold supermajorities in both chambers. State senators and representatives both serve two-year terms. House of Representatives. Each representative represents about 40,000 residents. Representative districts are named for the primary county in which they are located, and tend to stay within one county, although some districts contain portions of adjacent counties. The current composition of the House is 125 Democrats and 35 Republicans. Senate. There are 40 senatorial districts in Massachusetts, named for the counties in which they are located. The current composition of the Senate is 33 Democrats and 6 Republicans, with one vacancy. Legislative procedure. The General Court is responsible for enacting laws in the state. The two legislative branches work concurrently on pending laws brought before them. Lawmaking begins in the House or Senate Clerk's office, where petitions, bills, and resolves are filed and recorded in a docket book. The clerks number the bills and assign them to appropriate joint committees. There are 26 of these committees, each responsible for studying the bills which pertain to a specific area. Each committee is composed of 6 senators and 11 representatives. The standing committees schedule public hearings for the individual bills, which afford citizens, legislators and lobbyists the opportunity to express their views. Committee members meet at a later time in executive session to review the public testimony and discuss the merits of each bill before making their recommendations to the full membership of the House or Senate. Note that the public may still observe executive sessions, but may not participate in these meetings. The committee then issues its report, recommending that a bill ought to pass or ought not to pass, and the report is submitted to the clerk's office. The first reading of a favorably reported bill is automatic and occurs when the committee's report appears in the Journal of the House or Senate. Clerk. Matters not requiring reference to another joint House or Senate committee are, following the first reading, referred without debate to the Committee on Steering and Policy in the Senate, or placed in the orders of the day without debate, for a second reading in the House. If a bill affects the finances of the Commonwealth, it is referred to the Senate or House Committee on Ways and Means after the first reading. If it affects county finances, the bill is read and referred to the Committee on Counties of the House. Adverse reports are also referred to the Committee on Steering and Policy in the Senate, or placed without debate in the orders of the day for the next session of the House. Acceptance by either branch of an adverse report is considered the final rejection and the matter of the matter. However, an adverse report can be overturned. A member may move to substitute the bill for the report, and, if the motion to substitute carries, the matter is then given its first reading and follows the same procedure as if reported favorably by committee. After a bill takes its second reading, it is open to debate on amendments and motions. Following debate, a vote is taken, and if the bill receives a favorable vote by the membership, it is ordered to a third reading and referred to the Committee on Bills in the third reading. This amounts to preliminary approval of the bill in that branch. That committee examines technical points, as well as the legality and constitutionality of the measure, and ensures that it does not duplicate or contradict existing law. The committee then issues a report and returns the bill to the House or Senate for its third reading. At that time, legislators can further debate and amend the bill. Following the third reading, the body votes on passing the bill to be engrossed. The bill must then pass through 3 readings and engrossment in the second legislative branch. Should that occur, it is sent to the Legislative Engrossing Division where it is typed on special parchment in accordance with the general laws. However, if the second branch passes an amended version of the bill, the legislation returns to the original branch for a vote of concurrence in the amendment. If concurrence is rejected, a conference committee consisting of the 3 members from each legislative branch representing both political parties may be formed to effect a compromise piece of legislation. When a compromise is reached, the bill is sent to both legislative branches for their approval. A vote to enact the bill, first in the House and later in the Senate, is the final step in the passage of a bill by the legislature. Following enactment, the bill goes to the governor, who may sign the bill into law, allow it to become law without signing it, veto it, or return it to the legislature with recommended changes. If the legislature has concluded its yearly session, and the governor does not sign the bill within 10 days, it dies. This is referred to as a pocket veto. This 10-day period includes Sundays and holidays, even if they fall on the 10th day, and it begins the day after the legislation is laid on the governor's desk. A bill signed by the governor, or passed by 2/3 of both branches over his veto, becomes a law. It is usually effective in 90 days. The day after the governor signs the bill is considered to be the first day, and each succeeding day, including Sundays and holidays, is counted until the 90th. Laws considered emergency in nature take effect immediately upon signing if the legislature has voted to attach an emergency preamble to the bill. Adoption of the preamble requires a 2/3 standing vote of the membership. The governor may also declare an act to be an emergency law and make it effective at once. A special act takes effect 30 days from the day it is signed, unless it contains a provision to make it effective immediately.